Good afternoon. Today I'd like to finish off Chapter 8, Section 7, which is about the rights of the accused. First of all, there are some portions of the corpus of the Constitution, so before you even get to any of the amendments, that are designed to protect individuals even from being accused. There are two powers that are specifically prohibited Congress in Article 1. The first power is that of passing a bill of attainder. In Great Britain, when the Parliament wanted an individual to be seized, they would pass a bill of attainder, and that was essentially saying this person has committed this high crime, this misdemeanor. We want that person brought to the justice system. And so it was a law about a specific person for having committed a specific act. And throughout British history, you can read about bills of attainder. Generally, anybody who displeased the king would end up with a bill of attainder against him. So that is specifically repudiated in the Constitution. The second power that the Constitution is going to refuse the Congress is the ability to pass what's known as an ex post facto law. So I'm giving a lecture to you right now via YouTube. That act, in and of itself, right now, is completely within the law. Let's pretend that tomorrow it is decided that there should be a law, and the legislature passes a law that says producing content about the government over YouTube is illegal. And the president, the executive, signs it. That will become a law tomorrow. Now, what the government may not do is take that law, say, well, yesterday, Dr. Wells, you taught a lesson on government via YouTube, and therefore we're going to arrest you for doing that. That isn't allowed. Now, if I attempted to produce a lecture tomorrow after the law was passed, after it was signed into law, then I will have violated the law and can be seized. But for the acts of today, they may not pass a law later that say that those previous acts were illegal. You're not allowed to be ignorant of the law, but one can't predict what they're going to pass, and therefore one would constantly live in fear of ex post facto laws. The third right that is going to be woven into the fabric of the Constitution itself is the right of the writ of habeas corpus. The executive could potentially seize an individual and then never take that person before the court, could potentially just leave them in jail. Should such a thing happen, the individual's attorney or the individual's family would have the ability to go to the court and say, why is this person being held by the executive for so long? The court at that point would produce a writ of habeas corpus, which is to say, habeas corpus literally means you have the body. In other words, you have seized this person, and at that stage, the executive must bring the person before the court and explain why the person has been seized. Your rights to habeas corpus are ancient in the English-speaking world. The writ of habeas corpus comes about under Magna Carta in 1215. Now, in the United States' history, there are two prime instances where the writ of habeas corpus has been suspended. And by the by, only Congress has the power to suspend the writ of habeas corpus. So the president may not do so simply by his own will. During the Civil War, the writ of habeas corpus was suspended. And during World War II, the writ of habeas corpus, unfortunately, was suspended for Japanese American citizens when they were put into those camps. Those are the two precedents. There are no other precedents for that. So if we are not in a time of war, and I should mention, under the Japanese-American internment circumstance, their writ of habeas corpus was suspended by Congress as well. So there are three of the rights that are just interwoven into the very fabric of the Constitution itself. The Constitution then, in its amendments, provides many more rights to the accused. So let's talk about those rights as we discuss the process. Let's say that an individual has been appropriately seized. In other words, they have been arrested for more than enough probable cause, and now they're going to begin to go through the judicial process. What rights have they there? Well, the Fifth Amendment, first of all, says that everybody in the federal judicial process has a right to a grand jury. Now, what a grand jury does, first of all, grand jury just means big jury, from the French, grand, and we'll talk about petty juries here in a moment, which are small juries. The grand jury is an ex parte gathering, which is to say without a judge. The prosecutor sets it up. The prosecutor is there, and there is no defense attorney. The prosecutor simply tells this group of 13 to 24 individuals who are part of the grand jury what this person is being accused of and what facts the prosecutor has to back up that accusation. As long as that 13 to 24 people by a majority believe that there's reasonable belief that the person's committed the crime, the grand jury is going to produce what's known as an indictment. An indictment is the actual accusation. It is the formal accusation that a person is receiving from the court. Now, in some instances, the grand jury feels like the prosecutor's going too easy on the accused. And in those rare instances, the grand jury can come forward and actually provide more charges for the individual. Those extra charges are known as a presentment. And the prosecutor is bound to go forward with any accusations that are in the presentment. So, if there were a murder, for example, and they only brought the person forward for murder, but maybe they had moved the body or something like that, and there was an issue of abuse of a corpse, they could potentially, the grand jury could potentially have a presentment on abuse of a corpse, and therefore the person would be tried for both the murder, which was in the indictment, and also the failure to treat the corpse properly, which was in the presentment. The Fifth Amendment also provides a promise that individuals will never have to suffer double jeopardy. And short of it being part of a game show, double jeopardy is actually an enormous problem if it's allowed for. South Africa, for example, allows double jeopardy to occur. So what is this double jeopardy? Once a person has been tried for a specific crime and a jury has come to a conclusion regarding that, so if they find the individual not guilty, that person may not be tried for that crime, for that series of events, regardless of what happens thereafter. Regardless of what information is revealed, it doesn't matter anymore. Once the prosecution has failed, it has failed. It cannot attempt to get a higher court to overturn that decision of that jury. It is now over once the not guilty verdict has been decided. And jeopardy attaches as soon as the person was in danger of going to prison, in danger of receiving the death penalty. Anytime the person's in danger of losing liberties, jeopardy is going to attach. Now, in the event that somebody fails, or I should say the jury fails to come to a conclusion, 6 of them say not guilty, 6 of them say guilty, you have what's known as a mistrial. Mistrials do not have jeopardy attached to them. The prosecutor may take the same set of evidence, the same crime, to another jury and go through yet another trial, because mistrials are not a complete item. So, now, it has to be a pretty big deal for the prosecutor to go through the great expense of running a jury trial a second time. The prosecutor has to be fairly certain that this person is going to be found guilty and that somehow the prosecutors erred in the way that they presented the materials or something like that happened. But it has to be a fairly matter of great consequence for that to occur. Furthermore, if the government attempts to punish an individual and then fails to do so, so there have been instances where the government has started an execution and then failed in the efforts at that execution, jeopardy actually attaches when the failed punishment occurs. So in the state of Ohio, in fact, there was an individual who was electrocuted, was to be put to death by electrocution. That electrocution failed, and the individual went to the Supreme Court and said, I've already suffered the punishment that the state of Ohio set forward for me, which was death by electrocution. Just because they can't electrocute me properly doesn't mean that I should have to go through it a second time. And the Supreme Court agreed with the individual. So jeopardy had attached. That person could not be executed for the crime that that person had been found guilty of thereafter. So if the grand jury says, yes, go ahead and indict the individual, now the individual is going to go forward into a jury trial. You don't necessarily have to have a jury trial. There are instances that one might, in fact, waive the right to a jury trial. If it's a particular set of shocking facts that are going to come forward in the trial, one might be better off simply allowing a judge who maybe is a little more hardened and a little more accustomed to hearing grisly details to hear the facts of the case, rather than a jury who might be so shocked by the series of events that they will go for the most damaging punishment that they can find. So the individual actually has the ability to request what's known as a bench trial, which is just a trial before a judge. But let's, for the sake of of understanding what's going on, let's assume that a jury trial is what's going to happen. In the Sixth Amendment, you're promised the right to a speedy jury trial. Speedy, now there are several aspects to speedy that have to be examined. And in fact, the Supreme Court put down those 4 requirements. First of all, why was there a delay? Because if it was a delay because the defense requested more time to set up the defense, that's not the prosecution's fault. Secondly, did the delay actually harm the individual who was waiting for trial? So if you're sitting in prison waiting for a trial and you wait for 3 years, well, then indeed you have missed out on a great deal. If you're sitting in the comfort of your home for 3 years waiting for trial, that's a different matter entirely, and they take that into account. Number 3, they ask the question whether the individual actually had a delayed trial by the standards of that particular court. If it takes the court 3 years to get through trials, then that's how long it takes to get through them. And so the difference will only be a matter of if the court normally hears a trial after a month and you've gone 3 years, that's a problem. And number 4 is, did the defendant actually request a speedy trial? You have to assert this right in the same way that many other rights must be asserted as opposed to passively gained. So as long as all of those have occurred properly, then you will have been considered to have been given a speedy trial. And that speedy trial has to also be a public one. Now, there's the danger of it being overly public, and we've discussed that case before of the physician in Cleveland who committed murder against his wife, and he couldn't get a fair jury trial because everyone in Cleveland had already heard about the physician who had murdered his wife. That was too public. Simultaneously, these courts can't happen in shut-off rooms where no one can find out what's happening. The media has a right to have access to these trials, and the only thing that can cause protection in most of these trials are going to be items such as if it's going to involve a child, a minor, right? They're going to protect the minor. Those circumstances will not be public, but everything else is going to involve that a public trial. And with that being said, I'm going to stop this portion, and in the next section we will talk about how to select a jury.